We're meeting today on the lands of the Wurundjeri people of the Kulin Nation, and I take this opportunity to pay my respects to their elders past and present, and those emerging, and welcome anyone from Indigenous background here to this meeting today. Keywords. Keywords for India is a very important public lecture series that Australia India Institute has been hosting over the past few years. And what it does is it explores the complexity of some of these important words that are used by scholars and commentators. They reflect distinctive social and economic concepts. They reflect institutions, media, technologies. And what they do, what the lectures do, is they explore the meaning of these keywords, the significance and how they've changed over time, and what they might mean in different contexts. So what we hope is that the series just allows us the opportunity to reflect on how these words can offer new insights and understanding of India today. So we have our speaker. Our speaker is Jeff Redding. He's a new generation network scholar at the Australia India Institute and a senior research fellow at the Melbourne Law School. Jeff has a very distinguished career, and his research interests are in the area of comparative law and religion, Islamic law, legal pluralism, family law, and law and sexuality. He's lectured widely on these topics in North America, South Asia, and Europe, and he's been recently a visiting professor at the Institute of Higher Studies in Social Sciences, because I'm not even going to venture saying it in French, in Paris. A visiting fellow at the Kate Hamburger Colleague Center for Advanced Study of Law as Culture in Germany, and visiting faculty at the Sheikh Ahmad Hassan School of Law at the Lahore University of Management Sciences in Pakistan. Jeff has had research fellowships at the Yale Law School, Harvard Law School in the Islamic Legal Studies program, and the Columbia Law School, the Center for the Study of Law and Culture. He earned his JD from the University of Chicago Law School. So while he's based here at the Australia India Institute and the Melbourne Law School, Jeff is furthering his study of a network of non-state Muslim courts in India and the relationship of the Indian state with these Muslim courts. And he's also doing some research on recent development in transgender rights in Pakistan and India. So today, Jeff is going to deliver his lecture on the keyword courts, and he's going to be exploring some of the controversies around the idea of Muslim courts and Muslim divorce. And I will invite Jeff now to come and start telling us about this. So thank you, Jeff.
Thank you. Well, thank you everyone for coming, and thank you, Priya, for such a warm introduction, and thank you, Jonathan, for the initial invitation, along with Craig Jeffrey, the director of the Australia India Institute. This wasn't anything that I was expecting to do, but I was very excited by the opportunity to riff, if you will, on this idea, and this gives me the opportunity to kind of precipitate, if you will, a number of ideas that I've been playing with for a number of times, and which also form the basis, part of them form the basis for a manuscript, a book manuscript that I'm currently working on. I also want to thank Simon and Cassie for facilitating all the publicity and tech and all the day-to-day great work that you do. Thank you. So, courts. On November 26, 2014, protesters gathered on the stairs of what is often called the Old Courthouse in downtown St. Louis and conducted a brief trial of white St. Louis area officials loudly declaring all of the accused officials guilty as sin. St. Louis is a mid-sized city in a mid-sized state in the middle of what we now know as the United States. While medium-sized now, St. Louis was, at the turn of the 20th century, the fourth most populous city in the United States. The site of the 1904 Olympics even, St. Louis presently is now more known for failed public systems, dilapidated, if decadent, old red brick buildings, an alarming murder rate, and in the contemporary moment, popular resistance to racialized policing. The latter reputation has been cemented as a result of a local and then national conflagration, which came to be known simply as Ferguson. Ferguson then was the proximate cause of why these protesters had gathered on the steps of St. Louis's old courthouse in November 2014. Ferguson, a St. Louis suburb, was where a white police officer had shot a black 18-year-old by the name of Michael Brown, dead, on August 9, 2014. In the months following this killing, there were street protests. Police tanks rolled in response to these protests. Citizens marched, shouting, "Hands up, don't shoot." People were shot. In short, citizens and their state turned on each other, and communities across the United States turned into battlefields. However, this late November protest at the old courthouse was a different kind of protest, a protest that might be characterized as one directly highlighting the long history of the institutionalized and legalized operation of state violence against African Americans in the United States. Let me pause for a moment. You might have thought that you were coming to a talk this evening about courts and India, and you have. You are in the right room at the right time. My name is Jeff. But before we get to India, we're going to go on a little journey together. We're going to start in St. Louis, where I used to live and teach, and then move on to Paris, where I have lived and researched as well, and then finally get to Delhi, where I've also lived and worked. Along the way, I hope you'll see that the critical perspectives that I'm going to eventually take in relationship to contemporary courts in India, and also the non-state Muslim legal actors who are maneuvering outside of, around, and with these state courts, that this critical perspective is not solely about India, Indian courts, or Islamic courts. In talking about courts generally, then, let it be clear, I do not intend to paint a happy picture of these institutions or the alternatives to them anywhere. For example, the complicity of courts in racialized and institutionalized violence in the United States is a long-standing reality, uncomfortable as it may be to acknowledge. And indeed, if the particular courthouse chosen for this November 2014 Ferguson protest that I've opened this talk with is commonly referred to as the old courthouse, this appellation is, in some important sense, an effort to distance St. Louisans from an infamous legal trial which began in this courthouse in 1847. This trial that started in 1847 concerned the legal question of whether a black slave, Mr. Dred Scott, who had resided for a period of time with his white owner in northern states where slavery was prohibited, had lost through this period of residency in free states the legal status of being a slave. In short, the question in this trial conducted at the old courthouse in 1847 was whether Dred Scott, having lived in free states, was now himself free. Through many twists and turns, this local St. Louis trial eventually culminated in 1857 in a US Supreme Court decision which declared not only that Dred Scott was still a slave, but even more shockingly, that African Americans were not even US citizens in the first place, despite having been forcibly brought to the US or born on US soil. This was a cruel decision. And unsurprisingly, this Supreme Court decision's cruelty stoked further acrimony and discord between northern and southern states over the contentious issue of slavery. Just a few years later, in fact, this acrimony and discord would devolve into a bloody civil war and the disintegration, at least for a period of time, of the United States. For good reason then, the Dred Scott decision is often considered one of the worst, if not the worst, decisions of the US Supreme Court in its nearly 250-year history. Yet rarely is history learned from, and indeed more than 150 years after the Dred Scott decision, on November 26, 2014, protesters in St. Louis were rightfully decrying yet another instance of white-on-black violence emanating from their city. Just a day before this November 2014 protest, a St. Louis area grand jury had refused to indict the white police officer, Darren Wilson, who had killed Michael Brown. Darren Wilson's brutal killing of Michael on August 9, 2014, after which Michael's body lay dead and exposed in sultry streets for more than 4 hours, baking in the heat of a St. Louis summer sun, precipitated months of anger, public protests, and vicious retaliation by the state against civilians in Ferguson and all over the United States. In many ways, Michael Brown's killing and the outrage directed at the lack of accountability surrounding this killing, and the killing of thousands of other black boys and men over the years by police officers in the United States, produced the single most important instance of racial consciousness in the United States since the Civil Rights Movement in the mid-20th century. This consciousness took many forms. On this particular November morning, however, what had been precipitated was a trial of sorts. Protest leaders on the old courthouse steps read out to a crowd the names of white state actors who had been complicit in perpetuating violence against African Americans in relationship to Ferguson and across the St. Louis region for many years before. And when these protest leaders called for verdicts from the crowd shouted back, again, guilty as sin.
Hopefully we have a successful mock trial. We're going to go ahead and judge Darren Wilson. We'll never be defeated. The people united will never be defeated. What happened on those steps? Meetings to let black people all the time for non-performing. And now currently they have the National Guard station there.
So just a couple of months later, a similar, if more measured exercise was also carried out by a black citizens group who assembled a group of 12 black residents of the St. Louis region and asked them to examine the evidence that had been submitted to the largely white grand jury months earlier about police officer Darren Wilson's actions. This 12-member black grand jury returned with a decision by a margin of 11-1 to indict Darren Wilson for first-degree murder. A local news broadcast covering this development stressed, however, that it was a mock legal exercise and also reported what it characterized as the real grand jury decision from months before. These themes of real and fake legal processes, of real and fake courts, will emerge again when we eventually get to India and discuss what I've learned there about courts through the research and writing that I've done for several years now about non-state, private Muslim courts in India. The potentials and problems of both state and non-state, real and fake, illegitimate and legitimate courts will be on full display there, as they likely have been for you here, listening to and watching what happened in St. Louis in 2014. But before we get to India, we need to take a little stop in France, or more specifically, late 20th century France, and the works that Michel Foucault produced there. As many people in this audience are well aware, Foucault was a brilliant social and cultural historian. What is less appreciated is what an insightful legal theorist he also was, and not just in relationship to his general theory of power, legal or otherwise, but specifically in Foucault's institutional analysis of law. Indeed, in one of his less noticed interventions, namely Foucault's recorded discussion with two other French leftists in 1872, which was later published in edited volumes under the title of On Popular Justice, a discussion with Maoists, Foucault starkly laid out and explained his innovative belief of how and why the phenomenon of courtness, as he termed it, poses a direct threat to popular movements and interests. As a result of Foucault's skepticism, in this intervention, not only courtness, but something we might also more straightforwardly refer to just simply as courts, as a result of his skepticism about courtness and courts, Foucault expresses disagreement with other French leftists' then efforts to construct parallel structures and processes aiming to litigate outside of state structures fierce disputes raging at the time between popular actors and the French police. And this image is from May 1968 in the protests in Paris. Again, Foucault's intervention was in 1972, but this intervention was a continuation, and the events they're responding to was a continuation of the May 1968 disturbances. So expressing his basic skepticism of the non-state court project devised by his fellow French leftists, Foucault opened his 1972 intervention by noting how his, quote, hypothesis is not so much that the court is the natural expression of popular justice, but rather that its historical function is to ensnare popular justice, to control it, and to strangle it by reinscribing it within institutions which are typical of a state apparatus, end quote. So how does a court manage such a nefarious project, according to Foucault? In answering this, Foucault argues an essential kind of triangulation or strangulation of popular interests and desires that courts accomplish wherever and whenever they have been established. For example, at one point, Foucault quite vividly remarks that one should, quote, look a bit more closely at the spatial arrangements of the court, the arrangement of the people who are part of or before a court. What is this arrangement? A table, and behind this table, which distances them from the two litigants, the third party, that is the judges, their position indicates firstly that they are neutral with respect to each litigant, and secondly, this implies that their decision is not already arrived at in advance, that it will be made after an oral investigation of the two parties on the basis of a certain conception of truth and a certain number of ideas concerning what is just and unjust. Now, this idea that there can be people who are neutral in relationship to the two parties, that they can make judgments about them on the basis of ideas of justice which have absolute validity and that their decisions must be acted upon, I believe that all this is far removed from and quite foreign to the very idea of popular justice. In the case of popular justice, you do not have three elements. You have the masses and their enemies. Foucault's skeptical analysis of courts is both a comparative and a historical one. While Foucault's comparative analysis in this intervention is relatively ambitious, his historical analysis is more limited. And indeed, this is because of Foucault's diagnosis here that courts are actually a relatively recent invention, and one allied to the development of modern states. On this historical point, Foucault observed, quote, in the Middle Ages, there was a change from the court of arbitration, to which cases of dispute were taken by mutual consent, to conclude some dispute or some private battle, and which was in no way a permanent repository of power, to a set of stable, well-defined institutions which had the authority to intervene and which were based on political power, end quote. Foucault's historical description in his 1972 intervention on the superseding, or about the superseding of informal and consensual arbitration by formal and coercive courts is a relatively cursory one. However, Martin Shapiro, in his classic 1981 book on courts and comparative and political analysis, took up this historical development in much more detail, albeit one largely consistent with Foucault's earlier sweeping account. Martin Shapiro, his work is especially helpful in understanding some of the deep legitimacy issues confronting the modern state's courts. In short, that for all the realness of state courts, they are also fake when it comes to their popular legitimacy. Importantly, in his 1981 work, Shapiro develops an account of dispute resolution generally, placing state courts on a continuum of older, yet also still existing, forms of dispute resolution. Shapiro's continuum is one constructed around the variables of formality and what you might call distance from the litigants, and begins with the idea of a very informal go-between, namely someone who acts as a communicative intermediary and essentially just passes messages between two disputing persons, maybe someone running from one side of this line to the other side of this line. Shapiro's dispute resolution continuum then moves onward through the figure of the mediator, in short, a third party who is selected by the disputing parties to sit with them and work out a mutually agreed upon solution to their dispute. And then this continuum moves on to the arbitrator, a mediator plus, who is agreed to by both the disputing parties, but who is also empowered by them to formulate a resolution of their dispute completely of the arbitrator's own devising. And finally, this continuum ends with the figure of the modern state court judge. So we have the go-between, the mediator, the arbitrator, and the state court judge all on this continuum. To be sure, the modern state court judge is on Shapiro's dispute resolution continuum. However, such a judge is also an extreme phenomenon in that she is a person who is neither explicitly chosen or agreed to by either of the disputants. And again, the go-between is somebody who's traveling back and forth between these two sides, and the mediator is chosen, and the arbitrator is chosen by these two sides. The judge is also someone empowered to implement an external solution, what we call the law, to the dispute in front of the arbitrator, or the judge. The very formal modern state court judge then sits in extreme opposition to the very informal go-between, whose dispute resolution role is almost epiphenomenal to the disputing parties' direct working out of a solution to their problem. Moreover, for Shapiro, the state court judge, in her social and institutional distance from disputants, confronts a constant crisis of popular legitimacy. In Shapiro's own words, quote, "Contemporary courts are involved in a permanent crisis because they have moved very far along the routes of law and office and away from the basic consensual triad that provides their essential social logic." Because a modern state court judge, in contrast with a typical go-between, mediator, or arbitrator, is not chosen by the parties themselves, and also does not seek their explicit consent vis-a-vis the final resolution of the parties' dispute, the only thing recommending such a judge and her decision to litigants is either brute force or a somewhat mirage-like set of ideas and practices suggesting the alleged benevolence and fairness of the state and its officials. We can talk about these ideas in the Q&A. One of them is the idea of appeal, that because there is a mechanism to appeal a decision that it's somehow fair and somehow litigants and disputing parties should have more trust in it. However, for Shapiro, both force and these, again, sort of mirage-like ideas are unstable sources of authority and legitimacy for state court judges. The large themes that animated both Foucault's and Shapiro's earlier works on popular justice and the tense relationship between popular justice and state courts are also ones animating Mithti Mukherjee's recent sweeping historiographical work on the colonial development and post-colonial adoption of a certain species of justice for what we might call official India. In her recent book, entitled India in the Shadows of Empire, A Legal and Political History, 1774 to 1950, Mukherjee explains the species of justice as one deeply anchored in a triangulated idea of equity, where officialdom, first embodied by the British Empire, and then the anti-colonial Indian National Congress Party, and now the independent post-colonial Indian state, has positioned itself as an arbiter, or indeed a judge, of competing claims to justice amongst India's diverse and fractious polity. Mukherjee describes the colonial conceiving and deployment of this vision of justice in the following manner. Quote, this is Mukherjee's own words again. Quote, "Torn by internal conflict, the British claimed India was in desperate need of a neutral and impartial power at the helm of the state to secure both justice and order, or justice as order. Given that Indian society was divided into communities in conflict with each other, only an alien foreign power could be trusted to be neutral and impartial. In other words, for India to have any order and unity, the state would have to be exterior to the civil society or the nation. It was this invention of the discourse of imperial justice, coupled with a state representation and enforcement of India as a divided society, that turned the exteriority or foreign origin of the colonial state into its greatest strength rather than a weakness." Moreover, in taking on a similar court-like role, Mukherjee explains how and why the post-colonial Indian state suffers a certain distance from ordinary Indians in a way akin to the colonial state's distance, with all the problems of legitimacy that this entails. Mukherjee also contrasts the kind of dominant and imperial state-centered justice operative in colonial and post-colonial contexts alike as one opposed to and opposed by Gandhi's more personalized and renunciative articulation of freedom. And in fact, Gandhi's non-cooperation movement in the 1920s included as part of its anti-colonial efforts a plea that Indians boycott the colonial state's courts, and also that the Indian National Congress not allow lawyers into positions of leadership. So Gandhi had a very different notion of the role of lawyers and institutions in freedom. With Mukherjee, Shapiro, and Foucault then, we can begin to see and understand the distance of the state as court and also the distance of state courts, qua courts, and even perhaps the distance of a triangulated and beautifully abstract courtness, right? Sort of Foucault's view. Fundamentally, these three theorists aim to get us to appreciate not only the historical novelty of state courts, but also the fundamental crisis, to borrow a term again from Shapiro, a crisis of legitimacy that these courts and their accompanying states are constantly embroiled in. For the lawyers in the room, I want to emphasize here that this is not simply a counter-majoritarian problem or issue in which courts are understood to be purposefully and maybe delightfully designed as a check on the worst impulses of a too often demagogic democracy. Rather, what Mukherjee, Shapiro, and Foucault are emphasizing is that the state, post-colonial, is an imperial and colonial entity, or in other words, an entity outside of either majority or minority, as the British Empire was outside of both India's Hindu majority and Muslim minority. As such, the state has its own third-party interests. Under this view of things, then, a state court's adjudication is meant to maneuver between social frictions, which are always dangerous and which always pose the risk of civil war or rebellion. And as a result of this kind of maneuvering, it should not be at all surprising then for us to see courts in a so-called liberal democracy taking, in fact, majoritarian stands, if such majoritarian stands would comport with what is needed, at least in the moment, to maintain elite control. Courts, imperialism, liberalism, and majoritarianism, then, can be tightly weaved together. Moreover, such weaving happens not just in the work of social theorists, but also in the actual decisions of actual courts. I want to turn now to actual courts and actual decisions and actual India, and in particular to the recent attempt by the Supreme Court of India to regulate what is called triple talaq. Triple talaq is the thrice pronouncement in one sitting of talaq or divorce by a Muslim husband against his wife with the effect of immediate and irrevocable divorce. While the history behind the legality of triple talaq in Islamic thought, both around the world and in India specifically, is too complex to go into here, suffice it to say that some Muslim men in India have historically used this means of divorce to end their marriages. However, despite its historical use, triple talaq has been controversial because of the very sudden manner in which it leaves Muslim wives without spousal support, and also because there are other, ostensibly more humane forms of divorce, forms of talaq and Muslim divorce more generally, available to terminate a Muslim marriage. Yet, notwithstanding the existence of these humane divorce alternatives, and notwithstanding a widespread view amongst Muslims and non-Muslims alike, that there is something unseemly about triple talaq in particular, the Indian state has historically largely deemed triple talaq to be legal, as a result of this form of talaq having a long Islamic legal pedigree, or at least within certain dominant strands of Islam practiced in India and the rest of South Asia. Something changed about the legal status of triple talaq in India, however, with the 2017 decision in Shayara Bano versus Union of India by the Supreme Court of India. Or at least there is an argument that things changed with this highly anticipated decision. In fact, a 5-justice bench of the Supreme Court deciding this case split in a 2-1-2 decision that left no clear majority opinion. To be sure, many people attempted to assemble a majority opinion out of this unsatisfactory jumble of minority opinions. This would normally be done by, for example, finding overlap between the different justices' opinions and trying to find actionable points of law where at least 3 out of the 5 justices agreed with each other. However, in this case, each of the 3 opinions issued are confusingly written at a number of key points. As a result, it is often hard to know what any one or any single of these opinions is trying to do on its own, much less in conjunction with the other opinions. That being said, there is a sense that Shayara Bano banned triple talaq. In reality, 2 of the court's justices, including the Sikh Chief Justice, who sat on the 5-justice bench, and also a Muslim colleague, decided to say essentially that, as objectionable as triple talaq is, it was a matter of Muslim family law, and hence the Supreme Court on its own could not interfere with it. And the Christian justice who sat on this 5-justice bench issued his own opinion saying, essentially, that there was actually nothing to be done or decided in this case because another prior Supreme Court precedent, namely that of Shamim Ara, had already decided the issue. Yet the opinion that attracted the most press and popular attention was the final opinion issued in this case, written by a Parsi justice and joined in by a Hindu colleague. In the words of these two justices, quote, "It is clear that triple talaq is manifestly arbitrary in the sense that the marital tie can be broken capriciously and whimsically by a Muslim man without any attempt at reconciliation so as to save it. This form of talaq must therefore be held to be violative of the fundamental right contained under Article 14 of the Constitution of India," end quote. Or as numerous commentators paraphrase this opinion, it declared triple talaq to be unconstitutional. I'm reciting the different religious affiliations or ascriptions of each of the members of the 5-justice bench who heard and decided Shaira Bano. And again, there was one Sikh, one Muslim, one Christian, one Parsi, and one Hindu on this 5-justice bench, because this composition of the bench was highly conspicuous, widely commented upon, and most likely deliberate. Without a doubt, the issues raised in the Shaira Bano litigation were contentious and potentially explosive. Indeed, in this case, the Supreme Court had been asked to wade into highly divisive waters, where minority Muslim rights to self-govern the Muslim family were being questioned. Questions concerning the regulation of the Muslim family have been a hot-button issue in India both before and since the 1947 partition of colonial South Asia into Hindu-majority India and Muslim-majority Pakistan. Moreover, the adjudication of these kinds of questions have blown up in the Supreme Court's face before, quite notably in 1985 in the well-known, indeed infamous Shah Bano decision. In the Shah Bano decision, the Hindu justice writing the court's opinion made derogatory comments about Islam. By way of contrast, the 5-justice bench hearing Shaira Bano seemed to have been designed to signal the kind of imperial impartiality that Mithti Mukherjee diagnoses as being central to Indian officialdom in both the colonial and post-colonial periods. In Mukherjee's words again, such impartiality has been viewed as necessary for both colonial and post-colonial governance because India is composed of, quote, communities in conflict with each other. At least that was the British characterization. As a result, the 5-justice bench hearing Shaira Bano did not consist of 5 Hindu justices deciding an issue concerning the status of Islamic family law in India. It also did not consist of 4 Hindu justices doing that, or even a majority of 3. Rather, there was just one Hindu on this court bench, as there was one Muslim and 3 members of other communities altogether. In this composition of the Shaira Bano bench, then, the Supreme Court seemed to be trying to ensure that it would not descend into gross anti-Muslim bigotry. In short, that the court would try to remain above it all by being the careful and dispassionate arbiter of different communities' desires and interests that Mukherjee has so masterfully written about. But oh, if that was the intent, how spectacularly did it fail? Indeed, the assembled bench could not muster a unanimous opinion, much less an uncontroversial set of majority and minority opinions. Rather, 3 opinions came out of these 5 justices with no clear message, other than that there continued to be serious differences in Hindu and Muslim perceptions of what post-colonial Indian governance of the family should look like. Moreover, where efforts to manufacture a simple message out of this judicial jumble, and the Indian press was clearly angling for such a simple message, where these efforts to manufacture this message were successful, this so-called success, or the success at obtaining such a message, resulted in the Hindu or Parsi opinion, or the Hindu-Parsi opinion, becoming the Shaira Bano decision. Right? So this was, in press reports, it was constantly, the Supreme Court's actions were constantly characterized as banning triple talaq or making triple talaq unconstitutional, which was actually only the opinion paraphrased of the Hindu-Parsi 2-justice opinion. As a result of all this, it would not be completely or entirely unfair to say that in Shaira Bano, much as it had in Shah Bano, the Supreme Court allowed itself to fall prey to Hindu majoritarianism. Courts, imperialism, liberalism, and majoritarianism were then weaved together in the Shaira Bano decision. The Supreme Court of India, as a court with its own third-party interests, independent of plaintiff or defendant, or minority or majority, decided in this case that it had to side with the majority. Indeed, as the Chief Justice observed in his opinion in this case about the public clamor for action that the Supreme Court was confronting, quote, "The whole nation seems to be up in arms about triple talaq," end quote. Well, the Supreme Court of India took the side of public clamor in Shaya Bano. Sometimes a court might actually side with minorities. Arguably, however, this is for reasons far less to do with the thought that democracies require the existence of counter-majoritarian institutions like courts in order to control democracy's worst instincts. Or in other words, far less to do with the idea that courts should have a strong justice imperative, and far more to do with how courts, imperial and always teetering on the edge of illegitimacy, perceive their interests and needs. These needs and the ways in which they can overlap with minority interests have also been, in fact, on full display in another recent opinion issued by the Supreme Court of India. These needs also provide the theoretical framing for a manuscript that I'm currently working on, tentatively entitled A Secular Need, Legal Pluralism, Islamic Law, and the Making of Law and Governance in Contemporary India. In closing this talk, I want to discuss how the opinion in the 2014 decision in Viswalochan Madan versus Union of India is revelatory of this secular need, and then what I think we can take from all of our journeys together today. Viswalochan Madan versus Union of India was a constitutional dispute provoked in 2005 by a private attorney, Mr. Viswalochan Madan, in the Supreme Court of India. Mr. Madan instigated this case by filing what's called a public interest petition in the Supreme Court, aiming to completely shut down a network of private Muslim dispute resolution providers operating in India since the 1920s. This network is known as the Darul Qaza network. By way of background, Darul Qazas, or Shariat courts, or Muslim courts, or private Muslim courts, largely operate as spaces where Muslim women can get divorced from their husbands, at least in the eyes of religious authorities, and maybe also the state. Beyond aiming to shut down these Darul Qazas, Mr. Madan's petition to the Supreme Court also asked the court to ban the giving of fatwas in India. Mr. Madan's petition to the Supreme Court was dramatic, but so were the events leading up to it. Indeed, during the summer of 2005, shortly before Mr. Madan filed his Supreme Court petition, a long-standing fascination and disgust with Islamic law and legal authorities in India reached a particularly fevered pitch in India's national media. This furor was a consequence of a young Muslim woman's alleged rape by her father-in-law, and a mufti's pronouncement, or fatwa, that as a result of her rape, this woman should no longer be considered the wife of her husband. The way in which Imran's case, as this set of events was often referred to, was in fact not made a case, at least in front of the Indian state's family law system, seemed to demonstrate the ease by which religious and other non-state entities could subvert the Indian state's interest in regulating family status. This alleged subversion of justice sparked outrage across a wide spectrum of Indian government officials, social activists, and ordinary citizens. That a woman could be divorced via rape without the state being able to effectively intervene was eminently frustrating for institutions and people who wanted to believe in the power of their modern state against so-called pre-modern attitudes and practices, who want the state's courts, who want the state's real courts to be able to intervene against fake non-state courts such as Darul Qazas. Notwithstanding the seriousness of the issues raised by Mr. Madan's petition, the Supreme Court essentially sat on this petition without deciding it for 9 long years. However, in 2014, the Supreme Court of India finally issued its decision in this dispute. There are several aspects of the Supreme Court's opinion that, for reasons of time, I cannot go into here. What I do want to highlight briefly, however, is the way in which Imran's case figured prominently in this Supreme Court opinion. Indeed, with respect to this entire situation, the court emphasized how, quote, Imran's case is an eye-opener. Though she became the victim of lust of her father-in-law, her marriage was declared unlawful, and the innocent husband was restrained from keeping physical relationship with her. In this way, a declaratory decree for dissolution of marriage and decree for perpetual injunction were passed. In this way, victim has been punished. A country governed by rule of law cannot fathom it, end quote. While the court invoked the rule of law here, the court, in its opinion, also seemed to suggest that this was a case which raised questions as to whether the difficulties that Muslim women face in the Indian state's own judicial system, with its long delays, high costs, and general access to justice problems, which one might call the state court's own rule of law problems, warranted the operation of a parallel judicial system that may also, albeit differently, harm Muslim women. In considering this and other issues in this case, the court's opinion restated in relative detail the respective positions of the petitioner, Mr. Madan, and the respondents in this case. Interestingly, when delving into the respondents' or defendants' respective positions, the court decided to state the Union of India's position first, noting how, quote, this is the Supreme Court's words, "The stand of the Union of India is that fatwas are advisory in nature, and no Muslim is bound to follow those. Further, Darul Qaza does not administer criminal justice, and it really functions as an arbitrator, mediator, negotiator, or conciliator in matters pertaining to family dispute or any other dispute of civil nature between the Muslims. According to the Union of India, Darul Qaza can be perceived as an alternative dispute resolution mechanism, which strives to settle disputes amicably, outside the courts, expeditiously, in an amicable and inexpensive manner. The Union of India has not denied that fatwas, as alleged by the petitioner, were issued, but its plea is that they were not issued by any of the Darul Qaza. In any event, according to the Union of India, few bad examples may not justify abolition of system, which otherwise is found useful and effective." I call this focus on the government of India's position in this case interesting, because ultimately, in this case, the Supreme Court concurred in the government's position that Darul Qazas are, again, useful and effective. Indeed, praising the Darul Qaza system, the court, in its own words, described this system as, quote, "informal justice delivery system with an objective of bringing about amicable settlement between the parties," end quote. Finding Darul Qazas useful, then, the Supreme Court largely let them be in its decision in Vishwalochan Madan versus Union of India. While one could describe this as a victory for minority rights, it is a peculiar victory, one less rooted in a view that the Supreme Court should protect minorities, that the court is there for minorities, and rather seemingly a victory built out of a view that minorities and their institutions can help the state, that the state needs minorities rather than values minorities. Let me conclude. Tonight we have traveled from St. Louis to Paris and onward to Delhi. We have witnessed momentous debates and events concerning courts stretching as far back as 1972 and as recently as 2017. Across all of these places and time periods, 3 continents over 5 decades, we have witnessed citizens, often minorities, attempting to construct and practice law and justice in institutions different than those operated by the state. We've also seen state and state-allied actors characterize these non-state courts and legal institutions as fake or illegitimate and different than the so-called realness and legitimacy of state courts. Curiously, we have also seen eminent social and cultural historians and theorists raise similar legitimacy issues about courts, both state and non-state. I confess this can all be overwhelming, and at the very least, we have to know that something confusing is going on where we see both the state and Foucault agreeing, at least somewhat. So how are we to make sense of all this? In my book project, I have an argument that the state's fear of the non-state is a consequence of the state's need of the non-state. That, for example, when the Indian judiciary castigates non-state Muslim dispute resolution, it is because the state knows that it needs this non-state. Here, however, let me make a simpler point, namely that one ready lesson of today's travels through time and space is that courts are deeply, fundamentally political institutions. As such, one has legitimate reasons to invest trust and hope in them, as one has the right to invest in all political processes. But one has just as legitimate reasons to fear and distrust courts, as one should politicians too. This can imply many things. For example, if judges are politicians, then maybe judges should be elected, just like politicians. Indeed, such elections might go some way towards resolving the consent issue that Martin Shapiro has identified as at the root of state courts being in a situation of, again, his words, permanent crisis. Understanding judges as politicians might also buttress the case for judges being subject to term limits in the same way and for the same reasons that politicians are in many jurisdictions. But let me end by also saying something important about fairness, justice, and equality. These are the usual words and deeds of courts. As such, they can be inspiring ideals, but they can also provide the material of downright scary nightmares. So when courts invoke them, we are right to query, fair to whom, which justice, equality of what? And if we don't like the answers we get, we are also right to demand fairness to us, justice for us, equality of us. Moreover, we should demand these things whether in a street court or in the Supreme Court. During the 2014 Ferguson protests in St. Louis, protesters screamed out, "Whose streets?" replying in unison, "Our streets." I hope one lesson of today then is that we are also right to scream out, "Whose courts?" knowing that the answer should be our courts. Thank you.
Fantastic.
Should I stay up here or should we take
I
questions?
think, yes, I think we might just take a moment and see if we can get some questions. I might collect a couple of questions and then get you to answer them. So any questions here? Yeah, Imran?
Hello.
Hi.
An excellent, provoking talk. There was so much in that. I had one question that kind of had two sides. It goes back to the earlier part of your talk, which I found quite fascinating. The way you linked Foucault and kind of the transformations that happened in the colonial period. What I wanted to ask was, how did the colonial state sort of regulate, tolerate, or relate to non-state courts in colonial India? So what I'm trying to ask really is, what was the relationship between state or non-state courts in colonial India?
So this is a big question, and it largely depends on where you are in India. But Darul Qazas had been in existence since the 1920s as sort of a formal set of bodies organized by an organization in Bihar called the Imarat Sharia. But this is just one articulation or expression of Darul Qazas. And the term Darul Qaza is an Arabic term and is referencing a long tradition within Islamic legal practice for there to be more informal arbitration spaces. And these have existed for a long time before the 1920s. But the Imarat Sharia formed or made sort of self-consciously decided to create in a more organized manner a system, or what you might refer to as a network of Darul Qazas starting in the 1920s. And these largely functioned below the radar in at least that pre-1947 colonial India, as they existed for a long time post-1947. And so the lawsuit that was brought by Mr. Madan in 2005 really shined a spotlight on a set of institutions which had functioned in Bihar, Orissa, West Bengal, under the radar successfully, wide usage, large numbers of cases relatively adjudicated in them, without much controversy. It's only in sort of the present moment, if you will, that they have become kind of highly controversial. There's other similar institutions that have been operated or run and institutionalized to varying degrees of formality in Western India and also Southern India. So, there's a long history and tradition here, which has been largely unproblematic and hasn't been, deeply problematized by either state or non-state actors. It's only in the past 10 years or so that this has really sort of exploded as an issue.
Thank you.
Yes, Farah?
Great talk, Jeff. I really enjoyed it. I guess I'm still kind of puzzling over what my view is on your conclusion, where you suggest that, well, maybe there's an argument that judges should be elected more often than they are. Of course, judges are sometimes elected. And I'm really uncomfortable with that suggestion, and I'm trying to figure out why. And I guess it seems to me that, you know, it seems clear that there is something of value in judges being connected to people and understanding, you know, the constituency that they're serving and so on. But it seems as well that what we really value, it seems to me, in judges is expertise. And where the connectedness to people and so on might be well sort of served by having judges elected, it seems like expertise would be best served by having judges chosen by experts, which at least in many jurisdictions they are, right? And I'm not even talking about expertise in terms of, you know, technical areas of law, but, you know, if you think that you might be, you know, by virtue of having been trained in law and judging and so on, you're going to be better at looking at a situation impartially, weighing evidence, you know, being fair and so on. If you think you can be better or worse than that, and you can be trained to be better at that, then experts can figure out who's going to be best at that, then, you know, you might think, well, really it's not about elections, it should be about experts choosing experts. I don't know if you...
So I guess I would just respond, I mean, this is a long discussion, but let me just sort of point out as an initial matter that we do have, or at least in certain jurisdictions, there are popular justices, not just in the form of judges who are elected through an electoral process. I just voted in the state of Michigan, the United States, for judges. So in our state, you elect Supreme Court judges and probate judges, and even district level judges. But there's a much more sort of common form of popular justice or elected judges, if you will, through the form of the jury. And the jury in sort of constitutional and political and legal theory is, at least in some places, a very important repository of judicial authority and a certain kind of expertise, right? A popular expertise rather than an elite expertise or expertise which is premised in a certain form of legal education, you know, dependent on knowledge of and familiarity with and willingness to enforce a certain body of precedent. So I think we do, in many places, though it's probably not the majority, but in many places we do have popular judges quite unproblematically, and also, I would say, in those jurisdictions where they do exist, quite importantly. I mean, they function in the theory of governance in those places in a very conspicuous and important way. So I guess that would be one initial response.
I think, yes, please.
And they're not even elected, they're just selected out of, they're often just randomly elected from voter rolls or driver license rolls. So they're not even elected, they're just randomly selected.
Thank you once again for the sake of repetition, very wonderful talk. I was wondering if this is not just a characterization of judiciary, but also broadly about just the way law would operate in this kind of sort of situation. So what I'm thinking of is that we often blame that, you know, sort of how Indian constitutional law has gone our way, sort of that there's no coherence. There's often doctrinal coherence is missing, principal coherence is missing, and in many ways you feel that what court through this law is trying to do is just trying to ameliorate different groups, somehow trying to strike a balance rather than give a principled legal decision. And sort of law sometimes become a cover of that, and sometimes you even have to give up the cover because there's only too much you can even extend the formality to even cover that you are just trying to balance different groups, somehow keep peace within the society, somehow give something to all kinds of groups and just maintain the balance that is there. And traditionally that's not the function you understand law to do or judges to do, right? That's exactly why you have deliberative systems outside law and outside judges. And in that context, when politics and when all kind of big social decisions become judicialized, that problem, I think, even further, because unlike colonial judiciary, judiciary in post-colonial India is taking on many more political questions than it would earlier. And I think, so in some ways, someone might argue that the problem might even, if we understand what you say is a problem, will be much more than what it was.
If it's a problem. So I mean, I guess I would just say I agree. I think you see it not just in decisions like Shire Bano or Vishwa Lochan Madan versus Union of India, but also in the debates, the judicial debates about reservations and what percentage of positions can be reserved. It seems to be eminently a negotiation of one sort or another in front of the courts, and depending on which state they're in and where the politics of the moment are nationally.
Chair, thank you. Very comprehensive talk. 3 quick points. First is your calling cry for our courts is very persuasive, but let me play devil's advocate here. Late 1960s, we had the Naxalbari uprising, and they had their own courts. People were hacked on the streets, which continued in states like Bihar, Jharkhand. The Ranveer Sena had their own courts. They also are courts. How does that fit into this analysis you are putting in? Secondly, I believe in the example of this triple talaq, there were a huge number of women plaintiffs as well, Muslim plaintiff women who asked this triple talaq to be abolished. What if they stand outside and they say, what about our courts? How will you answer that? And the third thing is that there was this question of representation, and Farah mentioned about expertise. The weaving that you did from colonialism to imperialism to liberalism to contemporary India, these notions of representativeness and expertise, don't you draw the normativity out of that same liberal tradition? I mean, you are again falling back into something similar which already exists, right? On one moment you're critiquing liberalism, but drawing the normative aspects from it when you're suggesting solutions. And lastly, maybe I'm wrong, but it sounds a little conspiratorial in some ways that the state needs the other always. The non-minority has to be put down always because the court needs them to establish their own legitimacy. I mean, a little uncomfortable would be, but maybe many people may agree with it, but that's what I wanted to share with you, that's all.
Okay, thank you very much for all those points. Let me...
There's a follow-on from
Okay,
Nina,
okay.
and maybe then you can respond.
Okay, great.
Just connecting to what he said, that I just wanted to clarify that you were making a comparison with the St. Louis judgment of 2014 and the Shire Bano judgment of 2017.
Yeah.
You were saying, and that comparison and your theoretical framing is allowing you to arrive at the fact that people are asking for their courts, because courts essentially bring in majoritarian judgments which need not respond to what people come to the courts for.
Yeah, so just by way of clarification, I'm just using those 2 examples to say that in the first instance with the Shire Bano decision, that it is very complicated. And in a written piece, I would have to do a lot more footnoting and clarification. But there is a way in which I think that this has been allowed to become. We'll see in future judgments how this precedent is treated, but I think there's an argument to be made that this the court fell prey to majoritarianism in the same way that it did in the Shah Bano decision. So I mean, for purposes of my argument, that's an instance of majoritarianism. Now the court also, in the second opinion, the Vishwa Lochan Madan versus Union of India, the argument there is that, well, that same court, it's not the same court because it's a different bench of justices, but that same institution does take pro-minority stands, or what might be thought of as pro-minority stands also. So one dilemma or one question that's raised is, well, what can we glean from this? I mean, is the court just spasmodic? Or is there some way of articulating, understanding what it's doing that fits into sort of a larger set of patterns? And so the argument is that the court is maneuvering. Sometimes it feels that it has to take the majoritarian stand. And I think in the vis-a-vis triple talaq, as the Chief Justice said in his minority opinion, listen, there is a public clamor to ban this. And I thought that that observation was interesting. I mean, I think the court was under extreme pressure to do something about triple talaq. And so sometimes the court, for its own set of institutional interests and preserving its role, has to side with the majority. At other times, though, it finds it convenient to side with the minority, but not really because it values that minority or is trying to give them things like dignity and respect, but because it needs that minority. In this instance, it needs these private Muslim courts to take on so much of this family law adjudication because the state courts themselves can't do it. So it's part of an argument that courts, one way of understanding courts is that they have their own third-party interests, and they are constantly trying to maneuver between majoritarianism and minoritism and probably a bunch of other things. But that this is symptomatic of their sort of illegitimacy or disconnect with society. They have grown their own roots and they have become their own sort of monster, if you will. Sometimes they're on your side, sometimes they're not. But it's part of this way of seeing them not as part of liberal theory, but as, I'm sure there's some sort of economic theory which would describe this, but as operating in their own self-interest. Yeah,
I mean,
sorry, that was,
sorry to say,
yeah,
I
so,
think when we say majority, I think you sort of elided the question that's sort of asked,
Okay.
which is about the women, the gender question.
right,
So it's not about communities, but actually the court spoke about gender justice.
yeah, yeah.
So I think
So, yeah, so this is a very fair point from both of you. And again, when I write this up, I have to be much more careful, and it's also embedded in another argument, which is also linked to my work on gender. So without going off for 15 or 20 minutes about this, what I will say is that within every community, there is always a wide variety of interests. And so I've characterized this court as having the Muslim representative, the Hindu representative, the Parsi I mean, that is simplistic. But at the same time, I think it still bears attention that there was an attempt to construct a court that looked like this, and it spectacularly failed, and it spectacularly failed in all the ways that you would not want it to spectacularly fail. I mean, they could have just decided, they could have sat on this petition for 9 years, and that would be a failure, or 10 years, or forever. They issued an opinion, and you see all the splits that you kind of admittedly stereotypically, but stereotypically would expect. There's also, vis-a-vis, Muslim women and, the demand for reform of triple talaq, yes, but there are ways of arguing that. And this links to my work on gender and sexuality elsewhere. There are arguments for same-sex marriage. There are also arguments for it which are good and arguments which are bad. And the bad arguments, I think, are ones that tap into larger state and social homophobia. And I think there are also bad arguments to ban triple talaq, which are premised in larger state and social Islamophobia. So characterizing certain practices as barbaric, pre-modern, on and on and on, I don't find that to be helpful. So I know this is not directly addressing issues, but I think within that litigation there were a lot of really problematic arguments put forward by people who otherwise have very, I would hope and know that they have very good reasons for their opposition to things like triple talaq. But there's so it's not that we can divide it up into pro and against on any issue. It's also within being for something, there's good ways and bad ways for being for it. I know that that's not super helpful, but we can talk about it more later on.
I'll finish up with one last question. Oh, well, but maybe after. Okay, 2 questions at once.
Just an observation.
Yes, please.
I just wanted to mention that the triple talaq issue was driven by Muslim women and Muslim women's organizations. It wasn't enforced, it wasn't pushed on them, but they were the ones who were really at the forefront of the fight.
Some. I've talked to a lawyer that...
Yeah, it will be. It wasn't 100%, but
Yeah.
there was a large section who were.
No, absolutely.
And a lot of them
Yeah.
may have been for it, but could not speak up.
Absolutely. I think an ethnography of this case and the litigation behind it has to be written, and I sort of encourage someone to do it because there was a lot of behind-the-scenes maneuvering on multiple fronts, both in the court's initial taking on of this issue, and then also the ways in which lawyers and parties were positioning themselves. And I just don't think it's fair from what I know, and which I also don't feel at liberty to speak about, naming names and what people told me here, but it's very complicated, and there was a lot of good and bad politics behind this decision.
Last question from Jonathan.
Hi, sorry, I'm totally changing the topic now. Thanks for a really stimulating talk. You've gone through from like the American case, French case, Indian case, the story of like what I guess would be Western style courts and the state within, how the state is materialized, has power within these courts. And then in the Indian case, you talked about the state courts and non-state courts. I was wondering, does the state not materialize at all or have power within these, away from, so instead of like these Western courts, if you go to those, to like Islamic courts or to other courts, is the state not there at all seeking to have power in those courts as well? Or is it this kind of binary of the state courts versus non-state courts? Is it so clear, or is there another totally different story you could tell of?
Yeah, read the book. Yeah, I mean, the state is there in the non-state, but what I'm trying to do with the book is suggest that the non-state is much more central to the state's narrative than is traditionally recognized. So within the larger secularism literature, or the anthropological literature surrounding secularism, there's an idea that secularism is about the creation and management of the line between the secular and the religious and the state, and that state secularism is about setting up these two spheres and then, shifting that line as it suits state interests of the moment, or however you want to characterize the time frame. What I'm trying to do with the book is to say that the state actually has far less agency. It does have agency. The state is affecting the non-state. The state is affecting the definition of what is religious, what is secular, and what is the dividing lines between those things. But that the state is also a reactionary institution. The state's actions are also reactive to pre-state or post-state, or however you want to characterize non-state actors, and that the non-state has agency vis-a-vis the state as well. It's a two-way street, but it's often only the state's agency that matters to a lot of the literature. And what I'm trying to say is that the non-state has agency here too.
Right, well, this is precisely why I enjoy every one of these keywords talks, because you never quite know how the story is going to evolve around one single word. So this has absolutely been fascinating, Jeff. Thank you so much for this fantastic.
Thank you for the opportunity.